Hello, everyone. Thank you for joining us and for your patience. It took a few moments for us to get a few technical issues resolved, but we're glad that you're joining us now. Let me introduce myself. I'm Hans Felber-Charbonneau. I work at Democracy Reporting International, a Berlin-based NGO, on the Reconstitution Project, where we promote better public debate on democracy and the rule of law across the EU. This is funded by Stiftung Mercator. The session is organized with the Reconnect project, which is funded by the European Commission as part of the Horizon 2020 program, which also aims to reconcile Europe and its citizens through democracy and the rule of law. Our thanks go to the Leuven Center for Global Governance Studies for hosting us today. Now that you've heard all about our wonderful programs, I'm happy to move our conversation directly into the topic that you're all here to talk about today. With our great panel. We'll be talking about the long-term impacts of emergency measures introduced in Hungary, Poland, Italy, and Finland on the rule of law, these measures that were introduced to deal with the COVID-19 pandemic. Each of our presenter will take 10-15 minutes to go over the main developments in each country, and we'll be taking questions after the presentations. With that, I'm happy to introduce Professor Kim-Lane Scheppele from Princeton University to give us some light on the latest developments in Hungary.
Great, thank you so much. So what I'm going to talk to you today about is pandemic and dictatorship in Hungary. Just to give you a little bit of background, this is a chart that shows you liberal democracy scores. Along the bottom axis, you see the liberal democracy score of many countries around the world in 2008, and on the vertical axis you see liberal democracy scores in 2018. That means if a country didn't change at all, it should be right on the line, and if it got better in that decade, it's above the line, and if it got worse, it's below the line. And one of the things you see is that two of the countries we're singling out today, namely Hungary and Poland, have really fallen quite far, quite fast in the last decade, and that Hungary is really in bad shape. Now, I've called this phenomenon autocratic legalism because the reason why Hungary's fallen sort of out of the family of consolidated democracies is because Viktor Orbán, when he came to power in 2010, started this drive to consolidate power in the hands of one person, himself, and his party, Fidesz, and to end democratic pluralism in Hungary, but to do so by law. So Hungary is the example number one of this phenomenon of autocratic legalism. In 2019, Freedom House demoted Hungary from free to partly free, and then this year, the Varieties of Democracy Project moved Hungary out of the category of democracies altogether into something called a hybrid or a competitive authoritarian regime. Now, over this last 10 years that Viktor Orbán's been in power, this is just the background, I'm going to get to the pandemic in a second, but you need to know that it happens against a certain kind of background. When Viktor Orbán came to power, he drafted more or less single-handedly a new constitution that he rammed through the parliament and changed thousands of pages of laws. Most of the effect of those legal changes were to concentrate power in only his hands. So this constitution can be amended by a 2/3 vote of the unicameral parliament. And Orbán has engineered the elections since 2010 so that he always has this 2/3 majority, this kétharmad, this 2/3. Okay, now in order to change these laws and to do it right under the nose of the EU, the way that Orbán's done this is to do something, or to act, as I've called it, like a Frankenstate. So if you remember Mary Shelley's novel, Frankenstein, the doctor digs up all these perfectly normal bodies in a graveyard and then attaches the torso of one to the arm of another and so forth, but these all were once normal bodies. And if you think about those body parts as laws, then this is what Orbán has done. So very often he'll borrow something from one EU member state, attach it to something else from another EU member state, and in so doing create a kind of legal monster that concentrates all of these powers. But that very act of sort of, stitching together these things where he can always say, why do you bother us about this law when, for example, Finland has the same law or whatever? That's been one of the ways in which that he's tried to avoid criticism at EU level. Now, all of this is even before the pandemic, resulted in the European Parliament sanctioning Hungary under Article 7.1 of the Treaty of the European Union, which is the article that when passed determines that the country in question is at risk of a serious breach of European values. Unfortunately, this report now sits at the European Council, at the General Affairs Council, where it needs to pass by a 4/5 vote, and basically they haven't done anything. So all of this had happened before the pandemic. So what happened with the pandemic? Well, HVG is one of the remaining, I think the last remaining really independent news weekly in Hungary. This shows Orbán milking the pandemic for his own benefit. And as this little Photoshop picture on the right shows, Orbán has become a bit of an outlaw in polite European company since the pandemic started. So what does that mean he did? Well, just like Orbán always does, he waits for other countries to do things first, and then he appears to do the same thing. So he waited for a lot of other countries, including countries in the EU, to declare a state of emergency to fight the virus. And then he declared a state of emergency by decree on the 11th of March. He then put before the Parliament a law which passed on the 31st of March, which has been dubbed the Enabling Act for reasons you'll be able to see in a second. And this law of the 31st of March created a legal framework for Orbán to govern by decree. Okay, so other countries in states of emergency give their presidents or prime ministers the power to govern by decree in a fast-acting, fast-changing kind of emergency. The difference in the Orbán case is that his decree powers under this Enabling Act are literally unlimited, both in time, because the emergency doesn't have an end until he decides to call it to an end, and also in subject matter. So the law is not narrowly limited to matters that can be directly traced to the pandemic, but Orbán is given the power to overturn by decree any law in the country, just literally any law in the country. And he's issued about 150 decrees since this passed at the end of March. Another little feature of this Enabling Act is that many countries have postponed elections during the pandemic until people can vote safely in person. But the Enabling Act in Hungary cancels all elections for as long as the emergency goes on. Okay, now how did this work? Well, again, because I've warned you already that one of the things Hungary does is engage in autocratic legalism. What this law does was it bypassed a lot of the guarantees that the Constitution had put in place, even Orbán's Constitution had put in place, for trying to rein in states of emergency. So under the Hungarian Constitution, any decree issued in a state of emergency lapses after 15 days, unless Parliament explicitly renews it. And in the Enabling Act, the Parliament gave Orbán the power to renew his own decrees for as long as the Parliament, for as long as the emergency lasted, without the Parliament being able to cancel this. And if the Parliament had second thoughts during the emergency, it turns out the Enabling Act said Parliament cannot repeal this law as long as the emergency is ongoing. Even if Orbán decides to end the emergency under this Enabling Act, in order to repeal these powers, like Orbán can just keep going on declaring an emergency on and on, he can stop, he could start, and then he can have all these powers. In order for the Parliament to retract those powers, it needed a 2/3 vote to withdraw those powers from Hungary. So that's why when the Enabling Act went into effect, a lot of people, myself included, got pretty nervous about these literally unlimited powers that Orbán was given. Now, that's not all this Enabling Act did. So it also created 2 new permanent crimes now in criminal law. So one is that, again, hiding behind the observation that a lot of other countries were fining people for violating stay-at-home orders. In Hungary, any effort to interfere with responses to the pandemic emergency can be punished by up to 8 years in prison. So this is not just fines, this is prison. And you have to know that under the Enabling Act, the emergency is defined as not just the virus, but also all the economic consequences that flow from this, which is to say, it really could be a very long-term thing. So, and theoretically, the way this is worded, just objecting to measures being taken by the government for the virus or for this pandemic could subject someone to long jail terms. In addition, there's now another new crime which punishes people for the distribution to the general public of, quote, false or distorted facts. And that's punishable by up to 5 years of prison time. And the last time we got a report from someone from Orbán's virus commission or virus kind of emergency task force, we learned that there were 120 people already charged with this. And They're not usually charging, in fact, we don't know of any cases yet where they've charged journalists, what they seem to be doing with this law is going after journalist sources. So anyone from a hospital that sort of describes what medical conditions are like inside Hungary's hospitals are the ones who seem to have been targeted by all of these things. What else did the Enabling Act did? Well, the other thing the Enabling Act did was it enabled Orbán to issue these decrees, of course. And you look at what the decrees, what the content of the decrees is, and one big theme in a lot of these decrees is that the military has been mobilized to fight the virus in lots of ways in Hungary. So first, Orbán installed military commanders at the head of all hospitals, sort of displacing the medical leadership. And at the outset of the pandemic, at least 10,000 and maybe as many as 30,000 people were evicted from hospital beds in the country, even though they were terminally and or critically ill, to make room for these COVID patients. And, journalists have been coming up with a lot of stories of people who were just discharged without continuing medical care, many of whom died not from the virus, but from whatever else they were suffering from. But the military commanders ensured it all happened. And several hospital directors were fired when they resisted the orders of the military commanders. In addition, military units have now been stationed at 150 strategic companies to ensure their continued operation. And one thing that seems clear is that these military units have been exfiltrating information about the personnel files of employees, all personal data about clients, as well as any kind of trade secrets or other secrets involving production processes. What else? Well, another set of decrees just kind of overtly come out and violate EU law. So the Minister of Information, of Innovation, another Orbán innovation, that minister can access any personal information about anyone in Hungary in clear violation of the GDPR. There's nothing in the law that says how long, for what purpose, whether the person has to be notified. None of the usual GDPR protections are in effect. So this minister can access all personal information. Virtually all labor rights have been removed. So if a worker decides that they can't return to work because they're a high-risk person and their job would expose them to the virus, they can be fired rather than, take advantage of healthcare protections. And then there was this interesting case where on a Friday morning at 10 o'clock, about a month and a half ago, Orbán issued a decree naming a company, a publicly traded company on the Hungarian Stock Exchange. Orbán issues a decree saying the management of this company has to be swapped out. The military unit goes in, and by 2 o'clock in the afternoon, this company has a new board of directors, a majority of whom are Orbán's friends. And all of this was done, again, by decree. And they've modified judicial procedures by decree. So, for example, all lay judges have now been removed from first instance trials, which leaves the Orbán-appointed judges to rule alone. So a whole bunch of things would raise questions under EU law. Also, another theme in these decrees is that he's been disabling the opposition. So there were local elections a year and a half ago or so, and 50 of Hungary's largest 100 cities are now being run by opposition mayors. And what Orbán has done with the decrees is to remove all the funding sources that go into the hands of these mayors and to displace them to the counties in which these cities sit, because all the counties are run by Orbán's party. So all of these different sources of income, car licensing fees, parking fees, and then Orbán's created by another decree, special economic zones. Here you see a Samsung plant that makes batteries, and it's in the city of Guido. And the revenues from that plant, the tax revenues, used to go to the city. Now suddenly they go to the county. They've also, by the way, removed all political party funding for opposition parties. So there's a whole set of these decrees that what they have to do with the virus is not so clear, but what they do is they disable the opposition that won all these mayorships. So what has the EU done? Well, the Parliament, which has always been on top of this in Hungary, held a hearing on May 14th, and one after another, MEP stood up and said, we have to stop funding this. We have to find a way to cut funds to Hungary because we're funding this dictatorship. And Vera Jourova, who I think is actually, personally understands what's going on, but she's speaking for a commission that has decided not to do anything. And she suggested that, well, we don't really see anything wrong with this yet, but it would be really nice if emergency powers were lifted. We haven't seen an effective EU response. However, the threat of funding cuts has mobilized Orbán, and this is where things are standing now. What's happened is he's now said, well, you see, I'm going to give up my pandemic decree powers. And moreover, he's had his Minister of Information send out all of these letters to media and others saying, and you must apologize to me because you thought I was becoming a dictator, and I'm not. But there's a bill before the Parliament that will repeal the Enabling Act. But as I told you, the Enabling Act cannot be repealed until Orbán calls off the emergency. And so far, Orbán has not been ready yet, but this law is sitting there looking like it will repeal the Enabling Act. But here's the problem. Alongside the law that will repeal Enabling Act 1 is something I'm now calling Enabling Act 2. It's called officially Transitional Provisions. It's 247 pages long, and it's not an easy read because it amends a million other laws. What this law does when you work it through is it gives back to Orbán everything he's giving up by repealing the Enabling Act. The press has not figured this out yet. Okay, so Enabling Act 2, this is not past the Parliament, it's sitting there. There's a chance it could be amended. There's a chance that if it's exposed and there's an outcry, he might give it up. But this is what this law, if it passes, would do. It creates a new state of emergency called the state of medical emergency. And this state of emergency is set up outside the constitutional framework for states of emergency. So if you remember, I said that under the Hungarian constitution, decrees issued during a state of emergency they lapse unless renewed after 15 days. Well, that doesn't apply to decrees under this emergency because it's not under that constitutional framework. These decrees can remain in force for the duration of the emergency. In response to the EU's criticism, this emergency is limited, so it can only last a fixed time, and that is 6 months. The problem is it can be indefinitely renewed. And because of the way this new emergency is set up, Parliament cannot cancel this emergency, it cannot veto it, and it cannot override any decrees that are issued. So in many ways, it's worse than Enabling Act 1. Are there any legal limits? Not really. And in fact, there's this fuzzy language where the Enabling Act gives the government the power to suspend, quote, the operation of all institutions, programs, or activities that could promote the spread of the epidemic. And the language, the particular words used in Hungarian, could refer to suspending the parliaments, the courts, the political parties, and even elections. So it's very broadly worded decree power. Also in this Enabling Act 2, the military, we've already seen the military is now, enforcing this emergency all over the place. This expands the power of the military now to use weapons against the civilian population inside Hungary. And it might be comforting in the law that it says the military can use weapons to harm people, quote, up to but not including death. But it anticipates that the military is going to be actually on the front lines of this with weapons. And while the law says the military is out there to, quote, fight the virus, so far as we can tell, weapons don't really solve this problem. So under the guise of repealing Enabling Act 1, Orbán's going to enact Enabling Act 2, which is actually even worse because it has even fewer legal checks than Enabling Act 1. In fact, one of the things we can't even figure out is whether Orbán even has to publish the decrees that he will make under Enabling Act 2. And so this is what is now sitting before the Parliament. So where are we with Hungary? It's supposed to be bottom with an M line. This was a quote from Ken Roth just before, the director of Human Rights Watch, just before the pandemic. He already thought 10 million EU citizens are now living under authoritarian rule. And with the pandemic emergency, it will get worse. And so will the EU do anything about it? They haven't so far. So far, I've heard no noise about this. And if history is any guide, probably not. Thanks, and sadly.
Thank you for that very eye-opening and slightly terrifying presentation as to the situation in Hungary. Next, my colleague Jakub Jaraczewski will walk us through the situation in Poland, where the pandemic has collided with the country's presidential elections and the continuing rule of law standoff with Brussels. Jakub.
Thank you very much, ladies and gentlemen. Welcome. Thanks for tuning in to our webinar. Also, thanks to my esteemed co-panelists and also to the Reconnect project for co-hosting this. Finally, an opportunity for the Reconstitution and Reconnect projects to connect and do something together. I'm very happy for that. I will be covering Poland. Despite working for a Berlin-based NGO, I am stuck here in Poznań since 3 months already, and having some kind of a fly on the wall's view on what's been happening in Poland. So hopefully I can give you some interesting insight. I will be focusing on the potential long-term effects of the measures introduced in Poland, and I will focus on 4 areas. The first being the legal framework for the measures being introduced in Poland. The second being the situation of the freedom of assembly in Poland. The third being the reforms and legislative changes which have been introduced during the time of the pandemic and which are likely to stick around for longer. And finally, as the fourth part, the situation of courts and the judiciary in Poland. So, starting first, as some of you probably know, the situation in Poland is quite peculiar. Despite having a constitutional state of natural disaster, which seems to be the best suited to be introduced in the state of a global pandemic, the Polish government has elected not to use this state of natural disaster and instead has chosen to go with a statutory state of pandemic. Now, the situation in Poland is slightly different than in Hungary because the state of pandemic existed in Polish law already since 2008. It was introduced 12 years ago in a statute on preventing the spread of infectious diseases and has never been used before. Now it's been employed, and it does cause several problems. First being that the state of epidemic is not time limited. Unlike the state of natural disaster provided in the Constitution, which has term limits, might be extended, but only with the involvement of the parliament, the state of pandemic can be put into action indefinitely. And at this point, there is no any indication of at which point would the state of pandemic be lifted. There are being talks about the situation with the coronavirus succeeding to the point where lifting the state of epidemic could be possible. Now, the state of epidemic itself does not alter the composition of the Polish state. It does not enable the government, disable any of its branches, and so on and so on. Yet, however, it allows for limitations of human rights and freedoms, which I will get in a moment. And this law has been in the books for 12 years, and nothing has been done about this. So we have a very much a case of an old law causing new troubles, and the biggest trouble being no point in view where the state of epidemic could be lifted. The question of human rights and freedoms brings me to the situation of freedom of assembly in Poland. Now, just as many countries in the world, the moment the epidemic hit, Poland has banned all public gatherings, demonstration strikes, all kinds of mass public gatherings have been forbidden, with high administrative fines being levied against those who would organize such a demonstration or rally. And for most part, that's probably been a sensible thing. Now, we are witnessing a rather confusing situation. This ban on public gathering is being slowly lifted. Since the beginning of June, we can organize a gathering of up to 150 people in the open air in Poland. However, at the same time, the enforcement of the ban and those measures has been quite surprisingly uneven. Just a few weeks ago, we could witness in Poland somewhat double standards. In Warsaw, there was a demonstration led by Mr. Paweł Tanajno, who is an admittedly fringe candidate in the Polish presidential election, and he would lead a rally of small business owners and entrepreneurs protesting against the lockdown, protesting against the economic damage to their businesses. This demonstration was dispersed by the police. Organizers were fined, and you could see a giant cordon of police and military police halting this demonstration. A few days later, in Poznań, in my city, there was a rally held by the mayor of Warsaw, Rafał Trzaskowski, who was also the presumptive candidate in the presidential elections on the biggest opposition party. The rally was ostensibly about the 30th anniversary of Polish local self-government, but in practice it was a rally of a presidential candidate gathering his supporters. There were close to 5,000 people in attendance, and while social distancing and masks were not quite observed, I was watching this rally from a safe distance and witnessing people quite openly throwing caution in the air. And the law enforcement and the police did nothing. There was no dispersing of this demonstration. There was no measures taken against the organizers. There was no reaction from the government. And what I think happened is that the government selectively enforced its own measures. looking at what would be the possible political fallout, and noticing that dispersing a demonstration by a major opposition candidate in the presidential election could easily reach CNN, BBC, or Deutsche Welle and feature as a story. So those standards on the freedom of assembly are enforced in a not consistent way, and at this point you can't be really sure in Poland whether you can organize some kind of rally or demonstration or not. What will be the reaction? What will happen when you will try to hold this? There is no legal certainty, which is so direly needed whenever you're trying to operate, especially during a time of an emergency. As far as the topic of legal reforms in Poland, now the situation here is quite different from Hungarian one. The upper house of the parliament, the Senate, is under the control of the opposition. Every bill that goes to the Polish parliament must go to the Senate, and there it is being discussed. This situation has ended the practice of blitzkrieg laws passed by the previous parliament, which were enacted over the course of 24 hours or even less. Now the Senate is taking its time in most cases. And this also means that there is far more scrutiny and looking into the laws and their shape. So that's a little bit better. But on the other hand, there have been some major reforms. And I would just like to highlight two elements. One is the changes to election laws. As you know, Poland is under the ongoing saga of its presidential elections, which were supposed to take place on the 10th of May, ultimately happened but didn't happen. Now they are happening again on the 28th of June. And in the meantime, there have been many changes to the electoral law. Most importantly, voting by mail, which is now being enabled so that people in Poland and people abroad could be able to use vote by mail. Well, unfortunately, Poland doesn't have a long history of voting by mail. It's been present in Poland only since a couple of years and only in French, very limited circumstances of people with high degree of disability who could jump through several legal hoops in order to be able to vote by mail. Now, voting by mail is introduced as a general rule and an option for everyone. And this is happening on a very short timetable with many uncertainties of how this is going to actually work technically. And the fear is that those changes will remain and that those changes introduced very quickly without proper discussion, without proper consultation. I'm not even going to go into the fact that the civil society was not present at all during those changes. Is going to stay on the books, and we will have a permanently altered landscape of electoral law in Poland. The second problem is many of the measures and punishments, again, for violating those measures introduced in Poland were introduced not by means of a statute of a parliament. They were introduced by means of secondary legislations, resolutions, decrees passed by the government. Now, if you would at this point ask whether it is even possible to limit human rights and freedoms using secondary legislation in Poland, no, it is not. The Constitution clearly says that laws which limit or derogate human freedoms and rights must be enacted in an act of a parliament, and the secondary legislation can only deal with details and follow the primary legislation passed by the parliament. But unfortunately, at the same time, the Constitutional Tribunal in Poland, which should be reviewing those laws and should be ensuring legality and that the government is not going outside of the bound of the Constitution, well, the Constitutional Tribunal is at this point a hollow shell of its former self that's been fully captured by the ruling party and is subservient to the government and gives no guarantee of throughout fully examining those laws and finding them violating the constitutional standards, or regional standards, or international standards. So that would be it, and the government's use of the secondary legislation also brings a lot of concern. Now, finally, I would like to touch upon the situation of courts in Poland. Like in many other countries around the world, Poland has mostly shut down its judiciary during the pandemic. Poland has three major branches of judiciary: civil courts, criminal courts, and administrative courts. Civil and criminal courts continued to operate in a very limited way, with some most urgent and critical cases being heard, such as challenges to arrests or domestic violence cases or family-related matters, while the administrative courts shut down completely. And now, slowly, we're approaching the point where those courts are supposed to restart and resume working. But there are several issues with that, and I would highlight the two biggest ones. First is the overload of cases, the inevitable mass of cases which were overdue, which were not being heard during the pandemic, and which are going to likely overwhelm the courts in Poland. Now, the Polish government has for long said that they are adjusting Polish judiciary in order to make it more efficient and to bring it closer to the people. But the reality is that the Polish government over the last 5 years has not addressed any of the long-standing core issues with the Polish judiciary, such as inefficiency, such as the understaffing, such as the over-reliance on paperwork, such as lack of using modern IT tools, and so on and so on. Nothing has been done with that. And now those Polish courts with the existing issues are going to be hit by a, well, nothing short of a big wave of cases overdue from the pandemic. But it's not only the overdue cases, but we are also going to witness what is being increasingly described as corona cases. So new cases arising from circumstances connected to the pandemic. Cases such as cases related to violating the measures, cases related to challenging those measures, cases related to state aid being delivered or not delivered, cases related to various new problems that businesses and individuals face and their activity connected to the pandemic. And I was just a few days ago talking with a Polish judge, a friend of mine, and I asked him how does he feel about the coming months and the opening of the courts and the situation. And he told me that this is a little bit like standing on the beach and looking onto a tsunami wave coming at you and having nothing but an umbrella. And that probably describes accurately the situation of the judiciary in Poland facing what's going to happen once the courts enter the lockdown. And with this perhaps graphic but not exactly optimistic conclusion, I would like to thank you all for your attention.
Thank you, Jakub. Continuing in our European tour, Professor Cristina Fasone will now talk about Italy, which among the countries we're talking today was the hardest hit by COVID-19 and the first to introduce emergency measures. So we're looking forward to your insight.
Thanks very much, Hans, and thanks to Reconnect, the Leuven Center for Global Governance Studies, Reconstitution and Democracy Reporting International. I hope you can see my slide.
Yes, we can.
Okay, great. So, well, the Italian response to the pandemic has been featured by a gradual adjustment process from March until now. And I will briefly outline, first of all, the constitutional framework in which the state of emergency was declared, and I will focus on specific issues dealing with the jungle of sources of law which have been adopted in the aftermath of the pandemic, looking in particular at the way rights and freedoms protected by the Constitution have been restricted in the first stage and then in the second stage in which we currently are, looking also at the position of the Parliament in the response to the pandemic, which is again back in full operation, but for a while has been really marginalized also for the very nature of this institution, for the composition and its way of working. And finally, I will try to say something on the very serious conflict emerging between the state and the regions, being Italy a regional state, which has so far remained mainly political. So we have had just a limited involvement of courts, not really the Constitutional Court because of the narrow avenues to reach the Constitutional Court in Italy, but we might expect cases reviewed by the Constitutional Court both on limitation of fundamental rights and conflicts between state and regions in terms of violation of the Constitution, sooner or later appearing in front of the Constitutional Court as well. In Italy, there's no explicit constitutional coverage of the state of emergency. The Constitution provides for the state of war, which is declared by the Parliament, but not the state of emergency. However, the text of the Constitution has shows several references to emergency, in particular in relation to the power of the government to adopt temporary measures having the same force as ordinary laws in situation of necessity and urgency to be converted into law by the parliament by 16 days, and they have been extensively used also during the pandemic, even though I must say that despite the Constitution confines these measures to emergency situations, they are used on a regularly basis, unfortunately. So the state of emergency in Italy is provided by ordinary legislation. It was declared by the government without the involvement of the parliament on the 31st of January 2020. So before, I will say, the COVID-19, the major problems with the COVID-19 hit Italy, and is in place until the 31st of July 2020. It can be extended, and there is an ongoing discussion on this. But so far, it does not appear to be the case. Amongst the main effects of declaring the state of emergency, there is also the expansion of the powers, also rule-making powers, of the Civil Protection Department, which really managed the emergency, and which is placed in the framework of the Presidency of the Council of Ministers, so is linked to the executive, and has adopted really a variety and a number of orders also severely limiting fundamental rights. I will start by saying something on the jungle of legal sources in which we found ourselves in Italy. Not only a series of decree laws, which are these governmental measures to be converted by the parliament that have been adopted since the inception of the crisis. We have experienced a new, a massive adoption of another source of the law, decrees of the President of the Council of Ministers, which are administrative acts, formally speaking. They are not validated ex ante by the Council of State or by the President of the Republic before their adoption, nor there is any parliamentary approval or check on them. And a number of decrees has really limited the free circulation on the national territory, freedom of assembly, so a number of constitutional rights, without being, formally speaking, legislation, which according to the Constitution is the source of the law that is expected to under certain circumstances, limit fundamental rights. Nevertheless, gradually, and also because of the criticism that has been raised in relation to the abuse of these decrees, the government has gradually adopted also decree laws that provided the ground for the adoption of these administrative acts, while at the beginning this was not the case. And also, there have been procedures established for the involvement of the parliament in checking and in controlling the content of the draft decrees. So at least during the pandemic, and maybe in light of the criticism raised, some adjustment has been made. But this does not mean that there is a clarity in the legal response to the pandemic, because the decree laws that have been enacted, as has been said in other presentations, are composed of hundreds and hundreds of articles. So from the perspective of legal drafting and certainty of the law, the legal response has been quite questionable. Also, as anticipated, the Civil Protection Department has adopted a number of orders further specifying certain content of the decree laws and the decrees. But this is mainly a technical bodies, and also in this case there was no parliamentary or democratic control on the adoption of these decrees. plus other decrees that have been adopted also by single ministers, like the healthcare ministers or the Minister of Interior, sometimes even one contradicting the others. So the situation from a legal perspective was and still is rather chaotic, and on the top of that, we have had several orders adopted by the president of the 20 regions, well, 21 if we consider also the two autonomous provinces, and local authorities, sometimes trying to derogate or to deviate from what state legislation or state decrees imposed. So from a local authority, it was really not easy to understand which source of the law had to be applied, and this has proved to be problematic from the perspective of rule of law, clarity and certainty of the law. Although some adjustments have been made over time. Also, when it comes to the limitation of fundamental rights and freedoms, as anticipated, it was here I've provided a list of rights that have been more or less severely affected by the legal response to the pandemic. Some of them now, as in May, we entered the so-called stage 2 of the legal response to the reaction, which has lifted some restrictions, have been fully restored. Others are still instead severely limited. So just last week, we had the possibility to, again, circulate freely on the national territory, while this was restricted until 1 week ago. There is also a problem, again, with the freedom of assembly, with the right to defense, because the number of legal proceedings, even criminal proceedings, that can be dealt with is limited. So depending on the nature, for example, of the crime or the conviction, the proceeding is ongoing or is temporarily suspended. There has been a resort also to remote hearings or to written proceedings whenever possible. And this is the case at least until the 30th of June. Then the situation should be substantially improved. Also, when it comes to right to education, the management of the protection of these constitutional rights is disputable, at least, as it is deeply affected by the actual means of providing online teaching and online learning, which has been the case in a minority of cities, at least, and there are no yet plans clear outline for September, when the school year starts again. And also in Italy, the right to vote has been suspended for a while, because we were expected to vote in a constitutional referendum on important constitutional amendment reducing the number of MPs and senators, initially scheduled in March. It has been postponed in September, and the same is likely to occur for some regional elections, which were expected to take place this month. However, we must say that there has been a gradual adjustment for what concerns the limitation of the measures on the ground also of the principle of proportionality, which has been evoked on several occasions by the President of the Council of Ministers, appearing on the TV, on the national TV, and trying to explain to the people the prospective measures to be adopted. To some extent, also the institutional communication has changed a lot in this, during this pandemic, and other prominent figures that typically have been very much present in previous crises, for example, the head of state, have been rather marginal in the management of the crisis compared to the President of the Council of Ministers or this Civil Protection Department, which every day was informing the people about the death toll and the rate of contagion and so on and so forth. But also this new dynamic, this this new way to communicate to the people has been questionable, at least because before the concrete measure was adopted, it was with some unclarity. The content of these measures was presented to the people before, and then we had to wait for the publication or the presentation of the measures. So a lot of visibility, certainly for the President of the Council of Ministers, and an attempt to explain beforehand the content of these measures, but I'm not sure this has worked properly also from the perspective of the democratic control. Nevertheless, we can say that in stage 2, some of the most serious allegations of fundamental rights violation have been addressed, while there are new problems emerging now, for example, in relation to the right to privacy, because the proposal and the idea to proceed with the contract tracing through app. But lately, the government has proposed to launch this app to be used on a voluntary basis. So at least from this perspective, there is a voluntary limitation of the right to privacy to which we are subject. And who has tried to strike the balance? Certainly not the Constitutional Court because of the lack of cases that reach the courts, but also there has been a limited involvement of judges in general. So no many legal cases, no many legal proceedings. And also the Parliament has not been put in a position to deliberate on these measures, so that it could not work as usual. There has been a new tension emerging between politics in the age of populism in which we live, because the main coalition partner is a declared populist party, and the resurgence of technical expertise, at least in the most acute phase of the crisis. And the feeling is that there's no clear equilibrium that can be detected, not even now, where the situation seems to improve substantially. From the perspective of the form of government and the relationship between the parliament and the executive, sadly, in Italy, we have a long history of parliamentary marginalization or self-marginalization. So the attempts of the executive to bypass parliamentary procedures, even in normal time, goes back to some decades ago, and has been confirmed in the present situation, with a further element, however, that because of the composition of the parliament and because of the strict lockdown measure, for at least 1.5 months, the parliament was not able to work and to exert any concrete influence on the activity of the government, not even the parliamentary majority. And so the decision was taken not to amend the rules and to resort to just let some MPs and senators chosen from within each political group, proportionally to the size of this political group, to participate in parliamentary activities, while the other did not participate. So no like voting, no proxy voting, and no concrete effort to adapt also the rules, even on a temporary basis, to the new situation. And the paradox of that has been that the far-right populist forces has been the strongest advocate of parliamentary strengthening in this stage. So using this rhetoric of the strong need for a parliamentary control of the measures. But the good news, at least, is that since the end of April, the Parliament is fully back to its activities. So also decree laws have been thoroughly examined, and there is this new practice to evaluate and assess also the presidential decrees. Finally, I would like, as anticipate, say something on Italian regionalism, which has been really under pressure, and I think the pandemic has shown that there is an asymmetric level of constitutional loyalty, at least by some regions, that there has not been effective cooperation amongst the regions, even just in terms of providing medical equipment to the regions that were more in need at that time. So the system, the Italian regional system really seems not to work. And this is not just because the country has been asymmetrically affected by the pandemic. So we had the north by far the most hit part of the country in terms of rate of contagion and death toll. But also in terms of ability to respond and to adjust the strategy to the needs of the local population. So the lockdown measures and the current measures have been implemented and imposed on the whole Italian territory, regardless of these differences. And this has, while I think from a constitutional also perspective, this was needed, from the societal perspective, this has been harshly criticized. In general, the existence of, I would say, 20 different healthcare systems in Italy, because this is a shared competence, healthcare, between state and regions, has paved the way to a lot of criticism in the way, for example, some regions, especially in the north, have dealt with the pandemic. And even though, in my view at least, Article 120 of the Italian Constitution could have been used for the government to directly intervene in those regions, also replacing certain policy implemented by the regional authority, this has not occurred. To a large extent due to political reasons, because the regions in the north are led by center-right governments, while there is a center-left government at the state level. So not to exacerbate a situation which was already very, very tense. And however, many regions, especially in the south, have tried either to adopt more restrictive measures compared to what the government did, or more relaxed measures, as it was the case in Calabria, with an order that in the end was annulled by the Regional Administrative Tribunal, precisely because it was violating the state rules, and the state was the competent entity to act. So a lot of political and societal tensions going on, and not equal commitment to respect and comply with the constitutional rules, also from the perspective of autonomy, but also loyalty to the Constitution. And I will stop here.
Thank you very much for your presentation, giving us the highlight of a situation that's quite different from what the previous two speakers told us about in Hungary and Poland. I'd like to let everyone know that you can write your questions to us in the chat box in the control panel on your screens. We will be doing a Q&A after our last presentation, which is by Professor Martin Scheinin, who will tell us about the situation in Finland and some of the lessons that we can take from there. Please.
Thank you very much. I'm expected here to give some good news, presumably, that there are countries that have handled the situation well. And by and large, I will report on good news, that there are some lessons to be learned from the case of Finland as a constitutional democracy, how it handles an emergency, and specifically an emergency that comes through a dangerous epidemic. So there is some virtue here, not without problems, and I will address those. And the first point I want to make is that Finland, as a constitutional democracy, was prepared in the sense that there was thinking in advance, what if there one day will be a situation of emergency, a threat to the life of the nation. So there's a constitutional clause, section 23, which I wrote, by the way. Nevertheless, they have already destroyed it. They have amended parts of it, so it's not as good as it was when it was written and adopted in 1995. But nevertheless, there is a constitutional clause about states of emergency and the derogation from the constitution, which then will be possible. In addition, there's an Emergency Powers Act, which is based on the model that there is a preset list of 5 types of emergency situations, and then about 40 different powers that can be triggered. And the permutations are quite complex. So the type 2 emergency triggers powers X, Y, Z. The type 3 emergency triggers a different set of powers. And the health emergency has a quite limited range of those provisions applicable that can be triggered. But it's a fairly complex but thoughtful piece of legislation. One of the problems is that it hasn't been synchronized with section 23 of the Constitution, so there's a bit of ambiguity. What actually is applied? Is it the constitutional provision or is it the Emergency Powers Act? The basic point in both the Constitution and the Emergency Powers Act, and here they are in synchron, is that Parliament is not suspended. Parliament is very much in control. It's really the mode of operation of Parliament that changes, not the powers so much. The country is run by decree in a state of emergency, but Parliament reviews those decrees. There's a constitutionality check and then a quick procedure. The decree will stand or it will be null and void. So instead of a full legislative process, Parliament moves to scrutinizing mode, but it still is the supreme power, the supreme organ of the state. So this Emergency Powers Act and the system of retaining Parliament in the driver's seat means that emergency powers are tamed, and what results is a fairly good protection against abuse, and particularly political abuse of the emergency situation. And now I will run through a couple of features of this system. The first one is there are multiple steps that have to be taken in sequence. The cabinet, the politically responsible government, is in charge, but it cannot act alone. In step 1, it acts jointly with the President of the Republic, which is elected by direct universal suffrage, separately from the composition of the government, which is dictated by the parliamentary elections, and the election cycles are different. So there's 2 heads of the executive, the Prime Minister and the President. They must act together to declare that the preconditions for a state of emergency exist. So first, those 2 say, we have a health emergency. And only then the cabinet can proceed to stage 2, which is adoption of decrees. When a health emergency has been declared, a certain subset of the provisions of the Emergency Powers Act become in principle applicable. But for each power, the cabinet must issue a decree. We are taking into use powers A, B, C, and not D, E, F. Every decree will be scrutinized by Parliament before it enters into force. So these powers, these decrees where the individual powers are triggered, are subject to preview by Parliament. And once that is done, the cabinet, again, the government, proceeds to the implementation decrees. What is actually done through those powers? And those will be scrutinized by Parliament still, but afterwards. So they can enter into force immediately, those decrees, implementation decrees, but will be scrutinized rapidly within a week, for instance, by Parliament. So we have these three different steps that need to be taken in sequence. Secondly, about competencies, the phase one, declaring a state of emergency or preconditions of a state of emergency, we need the president and the cabinet. The triggering of powers requires cabinet and parliament, and so does the application of the powers, primarily the cabinet, but nevertheless ex post facto scrutiny by parliament rapidly. And this scrutiny by parliament includes a role for the Constitutional Law Committee, which addresses issues such as necessity and proportionality. It's not full constitutional review. In principle, these decrees can be incompatible with substantive constitutional rights as derogations through decree, but they are still vetted against necessity and proportionality, which is a limited constitutionality review, but nevertheless secures the power of parliament not only as a political organ, but also as a guardian of constitutionality. Thirdly, the principle of normalcy is inbuilt in the system. There's a requirement of specificity, there's a requirement of necessity. Emergency powers are used only when normal powers are not sufficient. There's a requirement of proportionality. Every measure must be temporary, with a short duration, with a possibility of renewal, but then the renewal decree must be submitted in advance to the parliament, 2 weeks before the first one lapses. So the government can apply powers initially after the triggering decree has been scrutinized. But if there's any extension of its application, it must be given to Parliament 2 weeks in advance. And then the principle of normalcy is visible in the sense that there are actually no powers in the Emergency Powers Act that would constitute derogation to the operation of courts or Parliament. And therefore, courts and Parliament have acted through adaptation rather than derogation. They have on their own introduced measures such as moving their work online in order to cope with the situation, but not imposed by government, but rather decided by themselves. Then I come to assessment. Surprises. This was the first time this system of the Emergency Powers Act, potentially Section 23 of the Constitution, was tested. So it was all in the in the safe, waiting for the occasion when we need emergency powers. Nobody knew what will actually happen and how the powers will be used. And of course, there have been surprises. There have also been errors, overreach, and I can list some. There was this sealing off of the Uusimaa province of the rest of the country, following Italy and the example of Lombardy. It was clearly premature and probably unnecessary. But 1/3 of the population was sealed off from the rest of the country in order to stop the epidemic reaching other parts of the country. And it was quite a drastic measure, which received a lot of criticism, and the government backtracked quite quickly. So it was in force only for 3 weeks, which of course means a certain degree of staggering the spread of the epidemic, but nevertheless was an overreach. Secondly, the internal EU borders have been closed, save for travelers that the border guards deem necessary, absolutely necessary. And there's no legal basis for this. There's vague talk about the EU accepting this, yes, but the EU doesn't regulate internal borders. It may recommend, but there should be national legal basis for those measures. I think the situation is the same in many EU countries. that there is no proper legal basis for the restrictions. But at least in Finland, this was done without legal basis and continues to date. I think there's been a misuse of the situation through factual action by the border guard agency instead of proper legal regulation. Third error was the cabinet triggered the power of compulsory work for people trained in the health sector, doctors and nurses. Luckily, they haven't taken this into use. But I think it's a far-reaching power, which would mean, for instance, calling people back from retirement, calling people back from the home, people who have moved to a different profession, or people who are working in private healthcare are suddenly pulled into emergency hospitals. So this was done to the degree that the power was triggered, but the implementation decree was never issued. I think that was an error. In general, there's been unnecessary bluntness of the measures, so that, for instance, restaurants were closed in all parts of the country for reasons of equality, instead of looking where are the hotspots, where do we really need to take measures such as closing down of businesses. But one can understand that in a situation like this, where there are so many unknowns about this particular virus and its spread, caution easily amounts to necessity when there is no evidence to the contrary. Those were the errors. And another caveat that I need to mention is that, yes, there are positive lessons to be learned from the case of Finland, but I think they must be taken with a grain of salt. And the salt is that Finland had very good luck. Things could have gone much worse had the situation escalated and become uncontrollable, such as the epidemic in Italy. So it's easy to be wise and cautious and constitutional when you have good luck. Anyway, the important surprises and positive lessons were that there was no expansion of the emergency powers. We constitutionalists, we always think that when emergency powers are taken into use, they are going to be used expansively and they are going to be increased. But in fact, the opposite happened, that the government rushed to trigger some powers which were never used, and powers that had been taken into use were found not so necessary or not so useful and gradually taken out of use. And a second presumption we constitutionalists have is that emergencies have a tendency of perpetuating themselves. Once you trigger emergency powers, it's difficult to get rid of them. But again, here the lesson was the opposite. And I think it was mainly because of the inbuilt mechanism for the renewal of the implementation decrees, which need to be submitted to Parliament 2 weeks before the expiry of the first one. This created a situation where the cabinet feared embarrassment and defeat, which is problematic in the middle of a crisis, and therefore sought alternative measures instead of trying to renew the use of emergency powers. So actually we learn that there's an inbuilt mechanism of getting rid of the powers that have once been taken into use, rather than their perpetuation. And what then replaces the emergency measures, the rule by decree, is specific small legislative amendments, often of temporary nature, which are submitted to Parliament quickly and considered by Parliament within a week, but through the full legislative procedure. We have had a couple of examples of this, the issue of the restaurants, their closing and the restricted opening has been handled through legislation, and so have a number of other issues, partly because there was no thought through clause in the Emergency Powers Act. The powers related to an epidemic, a health crisis, actually turn out to be quite limited and not really always fit for purpose of a contagious epidemic. And partly because of this fear of the government being embarrassed, including through the constitutionality control of the decrees, and therefore preference becoming the enactment of new laws. Then finally, this is a neutral, not a positive, not a negative lesson, is that it came as kind of a surprise that the actual declaration of emergency or the declaration that the preconditions of the emergency exist are not scrutinized by Parliament. I think all experts presumed that Parliament will have control on all aspects, but actually the first stage where the President and the Prime Minister together state that the preconditions for using emergency powers exist, factual preconditions, that is not subject to scrutiny. And we have here quite an interesting anomaly, namely that when the Prime Minister and the President on 16th of March stated that Finland is in a situation of an emergency, threat to the life of the nation, triggering potential emergency powers, they said it was on two grounds: the epidemic, an health emergency, and also an economic emergency. But nothing has been done pursuant to the economic emergency. Not a single one of the powers in the Emergency Powers Act related to economic emergencies has been taken into use. And this shows that it was an error. There was no actual emergency in relation to the economy. And here I'm not speaking of the devastating economic and financial consequences COVID-19 will have. Of course it will have, but they are not economic. It's not an economic crisis in the sense of the Emergency Powers Act, which is more of a centralized state-run war economy, rather than what is now happening, which is the extra spending, the budgetary allocation of resources, including subsidies to companies. It's kind of the opposite. So what the Emergency Powers Act drafters had in mind was a centralized socialist state-led economy with strict regulation, including of foreign trade and all other aspects of the economy. So the Emergency Powers Act proved to be completely useless for the purpose of the actual economic challenges. But as an anomaly, that has not been scrutinized. The President and the Prime Minister simply stated that there is also an economic emergency, but nothing has been done because of it. So it is a mixed message that I'm here delivering, but I think in the systemic features, Finland provides interesting lessons learned that show the way that preparing for an emergency is wise, and preserving the role of Parliament, including within Parliament the scrutiny of the constitutionality of the emergency decrees, is important. Thank you.
Thank you very much for that sober assessment. This leads right into our first question. You are covering a very large geographical area, many very different situations between the countries, so I'll do my best to balance the questions as much as possible. Apologies in advance to anyone whose name I butcher, but we do want to give credit to people asking questions. Taking on your last point, Professor Scheinin, a question here from Joel Grogan, which is, looking at the current design of emergency provisions, how should emergency laws be reformed in light of the lessons learned in the current crisis? Who wants to go first? Please, Kim.
Yeah, so actually, the Hungarian constitution, even Orbán's constitution, which took the emergency regulation directly from the Constitution before it, that looked like such a perfect system because, you know, as Martin said, it kept the Parliament in the loop. It required an overt declaration. It said Parliament could not be suspended. The Constitutional Court could not be suspended. It looked like a good system of regulation, and all it took was for the Parliament to delegate the power of indefinite renewal of decrees to the Prime Minister under perfectly valid legislation in order to completely upend the whole thing. So one of the things that this suggests is that, you know, design in advance, as Martin says, is important. Because in fact, one of the reasons why we knew that First Enabling Act was such a problem was that it nullified the constitutional checks that had been put in place. But the problem is that, you know, what you need is actually ongoing monitoring in the crisis. I mean, somebody has to be able to say, you know, are these measures necessary? Is this really proportionate? And they have to be people who aren't panicked by whatever it was that caused the emergency to be declared. Because, you know, I think, you know, the Hungarian case, I mean, they just started doing everything that Orbán ever wanted to do by decree, even though it had nothing whatsoever to do with the pandemic. But, you know, even in the Finnish case, what you see is that a lot of emergency powers were invoked and then never used. So, you know, it seems to me that the model that we've had of building a kind of constitutional structure in advance sort of fails in the moment, both directions, right? Because it can be neutralized and also because it can be abused. And also, frankly, because one of the characteristics of genuine emergencies is that people kind of don't know where they are in the middle of things. And so, you know, it seems to me that what we need to do now is to think much more about ongoing monitoring processes rather than just structures in advance.
If I may, I just spoke, but I would repeat that it's important to be prepared and to preserve the role of Parliament, including Parliament's role in scrutinizing the constitutionality of the decrees. And a tiny detail I would like to add to the rosy picture concerning Finland is that there's quite a strong Committee on Constitutional Law, which is a permanent committee of Parliament, which has an important role and high respect in the legislative process. So that has been the center of the scrutiny, also during emergency. And my colleagues, professors of constitutional law, weekly, often multiple times during the week, give legal opinions about these government decrees to that committee. So there's academia involved, independent academics whose opinions are public, who advise that committee, and their opinions are made public when the committee adopts its position. It refers to the professors and they give legitimacy to the legal argument. And there's a different layer. We professors who don't go to the committee, we have a blog. And then we can comment both on the decrees and what Parliament did and what it didn't do, and what the professors said and what they didn't do. So there's a degree of public scrutiny on the scrutiny advised by the academics.
I would say out of all the lessons that are to be learned from the Polish situation, and there are quite a lot of those, I would focus on one. The year is 2008, and you are introducing a law on infectious diseases, which features a state of epidemic. I was talking to the people who were involved in drafting this law, and they never envisioned this law to be used countrywide, as well as they never envisioned that a global pandemic will hit the world. And this law was on the books for 12 years. And it was not reviewed by the Constitutional Tribunal back when the Constitutional Tribunal was still fully functioning. It was not examined by the Ombudsman, and the academia wrote very little on this law, with some small remarks about how potentially some of the provisions are unclear. Lesson learned is, look after the law. If you see a problematic emergency measure, no matter how much of a science fiction it might seem to you, a potential use of it countrywide in connection to a global pandemic, review it, bring it to the attention of the Ombudsman. If you have the power, make the Constitutional Tribunal review it and answer some hard questions as to what might be the effect of this law, if it will be misused, abused, or perhaps used perfectly as it is written, but in a situation which was not envisioned by anyone. And that would be one lesson which I would want the people in Poland and perhaps worldwide to remember emerging from that. Thank you.
Yes, if I may, I really agree with what has been said regarding the importance of parliamentary scrutiny. But I also think that related to this, and given how the Italian Parliament reacted first, a process of in-depth reflection on how to change parliamentary procedures with a way to be ready for future challenges in terms of pandemic, whether it stays or the situation is improved, and to a bit reshape the way parliaments work so that the parliaments are not blocked by physical distance, and a problem of lockdown in the future should be seriously taken into account in Italy. But I see that also other parliaments have already maybe taken some measures in that respect. And this is important also because courts typically tend to intervene maybe quite late in the process, when the most acute phase of emergency is over. And so it's good that there is a democratic scrutiny also on the proportionality of the measure at first, done by the parliament, and then it can be for the court to further review the measures.
Thank you. Moving on, combining a few of the next questions, which go to the eternal question, which is what can be done, focusing more on Poland and Hungary. I have several questions about how civil society can contribute, what can they do to put pressure on the EU, to put pressure on the local governments rather, and to strengthen democracy. Kim, if you want to go first.
Yeah, sure. So this is really tough. So, I mean, one of the reasons why I led my presentation with all the stuff that had happened in the run-up to the pandemic was that the civil sector had been pretty much squashed already. Much of the independent media had been pretty much squashed already. And the opposition in the parliament had been more or less disabled. So when you go into a pandemic without all those pillars of robust challenge in place, then it's a lot easier for, an autocrat to seize power. And that's exactly what happened. One of the most nefarious aspects of this whole pandemic in Hungary is this law that bars people from spreading fake news, essentially, because the people who have been arrested are the ones who are the sources for the journalists. So it's the doctors, it's the people who report out the facts on which basis you would act, right? And that's been the most disabling, because that hadn't happened before this pandemic in Hungary. And there have been people arrested for posting on Facebook the true condition of what's happening inside Hungarian hospitals, for example. So, when you have a pandemic and an emergency in an autocracy, already things are disabled. So, the obvious thing would have been for the EU to do something 10 years ago. The EU has missed the ball on all of this. If the EU had even threatened to withdraw funding from Hungary much earlier, even the threat of withdrawing funding gets Orbán to act. So, the EU always thought it had limited tools. It keeps elaborating its tools, and it keeps not using them in the case of Hungary. When you get to the point where everything is already locked down inside the country, you need some help from outside. You need some scrutiny from outside to try to make all of this stuff work. So, right now, you cannot change the government in Hungary with a free and fair election, because there are no more free and fair elections. And when you get to that state, you need some outside assistance.
Jakub?
I would say that I could probably say a lot of truism about the importance of the civil society, and the civil society looking at various aspects of what's been happening, reporting and highlighting. But from the perspective of what is happening in Poland, it is very clear the critical role of those state institutions which remain out of the control of the government. And I would highlight the Polish Ombudsman, Commissioner for Civil Rights, Adam Bodnar, and his engagement with the civil society, and a critical example of how the national human rights institutions' interaction with the civil society, with academia, with independent experts is important. But also of the Polish Senate, the opposition-controlled chamber of the parliament, which is displaying a completely different attitude to the civil society than the lower chamber, Sejm does. And just as I was preparing for this presentation, I could see that the Polish Senate is organizing a roundtable on the impacts of coronavirus on tourism and the tourism industry in Poland, and basically raising very important questions regarding the economic and cultural rights of people in Poland who've been pretty much denied the opportunity to both profit from the tourism, but also to enjoy it and to have their, let's say, cultural rights of interacting with the culture undisrespected. And this also shows how critical it is for the pluralist, independent institutions, state institutions to engage with the civil society and ensure that this dialogue is ongoing. It is only made more visible in a situation like this when the government is making broad changes, sweeping alterations with very little consultation with the civil society. And when the consultations happen, I can frequently see representatives of the civil society whom I could describe as friendly to the government, if not outright supporting it. And this shows how important it is to have this free and open engagement. Thank you.
Thank you. We're going into overtime right now, but with the indulgence of our panelists, I'd like to wrap up some of the questions. On the EU, kind of zooming out a bit from the specific of Poland and Hungary, how do you see the role of the EU in the current rule of law issues related to the COVID-19 pandemic? What do you think that the EU's inaction or refusal to act says about the organization and its legitimacy? These wider questions around where was the EU, where is the EU, what are they doing? I don't know who wants to handle that one first. Please, Martin.
Well, this is the same. This is the moment when I say about the EU the same I say usually about the UN. There is no EU. There are different institutions, different organs. There's a commission who wants to do things, who wants to be guardian of rule of law at European level. There's a fundamental rights agency who wants to collect the fact and would like to assist the commission. There's a parliament who is deeply divided between the good ones, the ones who care about rule of law, and those who want to be buddies with autocrats. And then there's ultimately the council, which is governments of member states. And I think that's the bottom line, that structure of the European Union is such that too much power rests in its intergovernmental dimension, and that causes a great deal of inertia and unholy alliances. Sorry.
Thank you.
If I can say one thing, so this is a new commission, and there's an inexperienced president of the commission, and they just kind of went into their bunker when all of this started and said we don't have a competency in health, so therefore we can do nothing. But there have been so many things that have been engaged in the pandemic which fall clearly into EU areas. I mean, so for example, monitoring, surveillance, and data protection. Like many countries have now just burst the bound of collection of private data on citizens. And the EU has said nothing, even though that's a core competence that the EU has been proud of. The obliteration of labor rights has happened in Hungary. Not a peep from the Commission. Takeovers of companies. The closure of borders, like what happened to thinking through Schengen and what the temporary derogations from Schengen mean. I mean, there were a lot of things that were square on in the capacity of EU law, even without a direct competency in health. And you saw nothing happening. And, I just have this feeling since the new commission has taken office that mostly they have no idea what they're doing. And particularly with regard to Hungary, where, Vera Jourova knows full well what's happening. And I think she personally would love to do something. But she's getting stopped by the larger commission, which says none of your business what these countries are doing domestically. And if that's really where the EU is, then it's worse than useless, because people, in many countries in Eastern Europe, when all these countries joined in the Big Bang, accession more than 10 years ago now, there was this thought that if you join the EU, then it would be a guardian or a protection against going back to those old days of autocracy. And in fact, the EU might not have actually been that kind of thing when it was joined, But the fact that the EU is powerless in these circumstances where publics believed it could do something is really a recipe for the delegitimation of the EU in these publics. Not doing something is the crisis, rather than doing something that pushes its competencies. And I wish the Commission understood that. I disagree with Martin that the Commission's really always active, excuse me. But the Court of Justice has been active. Somebody has to bring it cases. And so far, the Commission is not bringing infringements when it should.
Thank you. Please, Cristina.
Yes, no, from the perspective also of the Italian situation, and being Italy once a strongly supportive country for the EU integration process, I must say that the handling of the COVID-19 crisis, at least at the beginning, was seen from the Italian perspective as further worsening the national situation and the national emergency, starting from Lagarde's speech, then corrected. And although we must say that the ECB then and the Commission have tried to take some concrete actions, but from the perspective of solidarity in the EU, particularly at the beginning, it's a complete failure.
I would only add one thing, which is in a recent poll organized by YouGov and conducted in EU member states, including Poland. 70% of people questioned in Poland answered in favor of strengthening the European Union's competences in the field of health and health security. And it is obvious that this is this moment where the EU has to answer some hard questions regarding whether the existing setup where the EU is supporting and has secondary role to the member states is tenable and can be continued. And it seems like there is genuine support in the EU member states among the general population for strengthening those competences and allowing the EU to react more strongly to health crisis. And yeah, probably a watershed moment for this. Hopefully the Commission and other EU bodies will pick up on this.
Thank you. And I have one last question on the mechanisms for derogation provided in different international instruments like the ECHR. This is a question by Julia Kapelanska-Węgowska. I'm just going through the examples. The COVID-19 pandemic has triggered a record number of derogations from the ECHR. Several countries have notified the Council of Europe Secretary General of these derogations. However, neither the Polish nor Hungarian governments have decided to pursue this step. Would you care to comment on this?
Well, the Hungarians will comment, will derogate when they start seeing lawsuits coming that may challenge them, because of course the point of derogation is not just to notify, but also to, in some sense, immunize you when you get to cases at the European Court of Human Rights. But this is where, we have to put this in this larger context of what's been happening in the Council of Europe. The European Court of Human Rights has been running scared for years and been backing off a lot of the protections that it used to offer. So one of the things it's done with regard to Hungary, which means that Hungary has to pay no attention whatsoever to that court, is that the court said about a year and a half ago that in order to exhaust domestic remedies before you can bring a case to the Court of Human Rights, you have to go through the Hungarian Constitutional Court. It used to be the case that that court couldn't offer a kind of tailored remedy, so all the cases bypassed it. But now the court has changed jurisdiction, and I see on paper why you would think the Constitutional Court would offer a remedy. The problem is the Hungarian Constitutional Court is totally captured by the government, and it has absolutely no timeline by which it has to decide cases. So cases that should go to Strasbourg go up to the Constitutional Court, and they just sit there. Nothing can get to Strasbourg unless the Constitutional Court says something, and therefore the case can proceed. So the Hungarian government knows that no cases will get to Strasbourg without its permission now. And therefore, does it really have to derogate? Does it have to actually worry about this? Absolutely not. So that's what you're seeing. This is the result of that terrible set of decisions by the by the European Court of Human Rights. And so basically there's no jurisdiction in Hungary right now.
I would say in Poland, the decision not to derogate from Article 15 of the European Convention and also of not triggering Article 4 of the CCPR and derogating from that instrument was likely closely linked to the fact that the Polish government chose not to invoke the constitutional state of emergency, did not invoke the state of natural disaster, which in itself provides for limiting key rights and freedoms, and probably tried to paint a picture of an emergency, but not of the highest emergency. And there was the whole quite contrived explanation why the government is not triggering the state of natural disaster, which also needs to be linked to the Polish presidential elections, which would be postponed if the state of natural disaster was to be triggered. Well, they were postponed, or rather not held eventually. So it kind of all came up back at the government. But still, there was a little bit of a discussion on this, and the outcome was that there was no derogation, because in Poland, it is an emergency, but it isn't an emergency. It is a crisis, but it isn't a crisis. And the whole situation is about as compounded as it can go. Thanks.
Yeah, my observation is that indeed the number of derogations or countries derogating is unprecedented. If we take the American Convention, the European Convention, and the ICCPR jointly together. Second observation is that the mechanisms are fairly weak that are automatically triggered in respect of derogations. So primarily a derogation is a shield for the government when the complaints come. It's an excuse. We did it, yes, but we did it because we had an officially proclaimed emergency. However, the Secretary General of the Council of Europe would have the power to ask for special reports from countries who did derogate and who did not derogate. And I think this might have been a good occasion for the Secretary General to utilize that power. It would have triggered a separate reporting procedure on COVID-19 measures by governments to Council of Europe, not the court. And then in the ICCPR, we have the General Comment 29 by the Human Rights Committee, which is quite a instructive instrument in taming emergencies, taming emergency powers based on the principle of normalcy, which then will be utilized in the reporting procedure. So irrespective of what cases come, countries will be held accountable with a long delay when the regular report arrives at the Human Rights Committee. Thanks.
Okay, again, in relation to the Italian situation, which didn't ask for derogation, I think given the length of the Italian proceedings, I'm not sure even in case of derogation, this would have really changed the situation. And considering the way the legal proceedings are managed now with further delay, I wonder, once the case sooner or later will reach the European Court of Human Rights, how the systemic violation of Article 6 of the ECHR will be seen in light of the way legal proceedings, including criminal proceedings, have been dealt with in Italy right now.
Thank you. And on that note, I would like to thank all of you, our panelists, for your time this afternoon, as well as everybody who are still watching. Gives us one indication that there is still thirst for more knowledge on this issue, and the public debate continues. So on that note, I will thank all of you and wish you a good end of the day. Thank you, everyone.
Thank you very much.
Yes, a round of applause for all of our speakers.
Thanks.
Thank you.
Thank you.
Thanks.